this session by special guest and resource person, Dr. Y.V. Kiran Kumar, sir, Assistant Professor, Geetham School of Law, Visakhapatnam. We cordially invite you, sir. I take this opportunity to introduce, sir. Sir, Dr. Y.V. Kiran Kumar, sir, is working as an assistant professor at the Geetham School of Law, Visakhapatnam. He completed his LLB, LLM, and PhD from Andhra University, Visakhapatnam. Sir is a product of Andhra University. He also completed PG Diploma in Cyber Law and Humanitarian Law from Nalsar, Hyderabad. He qualified for UGC NET and also selected for UGC NET JRF. He was awarded with Periyanarayana Gold Medal for Best Thesis in PhD in Law for the year 2022 from Andhra University. His field of specialization is international law and his areas of interest are international trade law, conflict laws, and laws and technology. He has published more than 20 research papers in national and international journals. LLM dissertations also has been done under his guidance. E-banking frauds and Indian legal perspective.
Ma'am. All these are not required because they are very elders. In front of them, if you are reading about me, it is not good. Okay, no problem, ma'am, no problem.
Only
That's enough.
5 minutes, Kiran, please.
Ma'am.
Sir presented various papers. He presented recently a paper on the right to land as a human right, arguments for specific IS term in ICSSR sponsored two-day national seminar on the theme of land records and rights, laws, governance and challenges organized by Damodaram Sanjeevaya National Law University on 19th and 20 February 2023. He participated in seminars, academic activities, national and international webinars, and virtual conferences. It's my pleasure to invite you, sir. Please address the program, sir. And I request all of you to kindly mute your mobiles. Sir, please take over, sir. Over to you, sir.
Ma'am, may I proceed, ma'am?
Please, sir, please.
Yes, ma'am. Thank you, Bhagwi, ma'am, having good words about me. Good afternoon, one and all. I'm conveying my heartfelt greetings to all the authorities who are presented there in that online meet from the university, and I'm also conveying my respect to all the leadership who are actually leading these programs, and also the law school authorities and the faculty members and all other mentors and coordinators who are involved in that program, and student friends. Okay, you know that today topic that is intellectual properties and how they are related to the startups and what is the importance of these two in the contemporary world. If you understand in that way, yes, of course, it is very late to initiate this kind of program. What I mean to say is, by March 2023 itself, a good beginning, which is came from the central government, is stopped. That is, they are giving extensive support to all the startups to get their IPR protection through the different agencies. Yes, of course, initially it is started for 3 years. It started in the year of 2016, and then it extended another 3 years. It is ended by this year of 2023. But anyway, some backing support always there with the government and also different agencies to protect the interest of the startups. So the reason we know very well why, because whenever you are initiating a small company, definitely it's facing a bit difficult to sustain when you competing with other companies, and also it is very tough to gain the financial sources when you have that ambition to run that company in a long term. So in that way, the agencies are thinking and they are providing a different kind of support to that startups. But before going to that, what is exactly a startup? So what generally we might see in these different laws, there, I hope this slide is visible to everyone.
Yes, Kiran.
Ma'am, Bhargavi? Okay.
Yes,
Okay.
yes.
Yes, sir.
Yes, there you can find the landscape of the startups. So till now, you can find nearly 6,97,938 startups which are there at Hub. So they register their names. At the same time, and these Indian government is actually given the exemptions to that startups. So that conversely, you can treat them as a 3,000. Okay, so thereby you can understand the importance of the startup, how these government is actually taking care of those startups. So with that landscape, if you go to that understanding of the startups, so what exactly a startup means? It's nothing but a private company. If you understanding through this Company Act 2013, and it is nothing but a partnership act. If it's nothing but a partnership act, if you understanding through this Partnership Act 1932. And recently we have the 2003 Act where it is actually this enactment came into enforce, that is Limited Liability Partnership Act. And that is also merged into this startup. So that is also a very nice initiation taken by this government. And if any form, if it is fitting in these terms, which is there in 2013, and also this Partnership Form Act, then if it is meant for the product manufacturing, and if it is availing any service to the public, and if it is deeply involving into the commercial aspect, then you can treat that as a startup company. But thing which we need to consider its value and its time when it is existed and up to what time it is run, within which time we actually consider that as a startup. For that, we have a normative, that fixed terms. That is, if it is after, and from 0 year to up to 10 years, you can consider that as a startup. So 2016, when that central government is initiated one program related to the scheme of IPR protection in related to startup, there you can find these years, they are clearly mentioned. Up to 10 years, you can treat one company as a startup company. But the added or extended condition is that company need to below the value of the turnover value is need to be less than 100 crores. In that time, in that situation only, you can consider that as a startup. And another thing is abstractive concepts. So those are scalable business model. What are the scalable business model? For government initiation, for the understanding of that perspective, scalable business model means the startup which is carrying the potentiality to generate the employment, then you can treat that as a scalable business model. And another thing is, it is very worth to consider that company, and then after with that consideration, if it is in a position to generate the wealth, then in that time, by seeing that future wealth, this government is actually giving that support at the initial stage of that beginning. So that is the reason why they are taken this attribute. And if you interest, then you can understand what is a startup. Okay, so then we can see the present situation, and these all the that new companies, they are belongs to different sectors. All these are now they are actually falling under the category of unicorn business models. A unicorn business model means one company which is exceeding the 10 crore that value of value, then you can treat that as a unicorn model of business, and that need to be held by the private person, then only you can so that Jepto is actually started in the year of 2020, and it is initial funding is $592 million. Now that company turnover, the income value of that company is $18.9 million. That is income, not the what you call company's value added thing, and not the overall value of that company. So that is the income of that company, and you can find out in the latest Business Times report. There you can clearly see each and every company which I mentioned. These are the top 7 companies which I taken from the top 20 listed companies. Okay, and if you see that I mentioned that a scalable business model. So that Jepto is giving the employment to that 1,656 in that it is created that job opportunities. Okay, in that way you can understand what is the rampant in nature related to the startups. Okay, and I mentioned here that unicorn landscape also. So this, for sake of understanding only, I mentioned it is not that much important. Whatever the importance, whichever in and around of that the startups taken place, and why these intellectual property changed their pace to grab the attention of the startups. In that way, to understand, I mentioned these figures. Till now, the value of all you can treat them as a 10% billion dollar, $10 billion. Okay, so then the position of India across the globe, which you can understand. Bangalore is occupying the number 1 position in regional level. That would mean in South Asian level. Bangalore is the number 1 position. And in every day, if you consider, you can find 2 startups. They are starting their business. They are starting their incorporation, and it little bit more when you purely going with the technological related companies. IT companies is more, it is exceeding the 2 number. I'm actually taking the average number while taking into different companies into consideration. Okay, and when you comparing with the global aspect, then India is carrying the 3rd position, and for the to see that perception of starting companies ecosystem. Okay, and number 1 position is USA, and China is carrying the 2nd position, and India is the 3rd one. Okay, then with this understanding, now I hope you have a small idea and how this nature is very dynamic. So startup nature is very dynamic. In that way, you can understand. Then come to the little known domain, which is our intellectual property. So all you might be studied and hear this intellectual property rights, because we have that subject as a legal student. We must study that subject. So the nature of intellectual property, we know that it is a intangible property and it is movable in nature. All these are not important. You can understand by understanding the nature of any property, what kind of nature it is carrying, what kind of attributes we need to identify in relation to those properties. But most important things which we need to understand, keeping the view of startups, these IPR rights are purely territorial in nature. So if you incorporate your company here in India, if you want to get protection from the government, and more particularly that protection was only related to your intellectual property rights, you can only get the protection in India, not at international level. So that is a lacuna, but it is not lacuna. The way you are taking your claim to that government is important. Straight away, you are taking that claim without mentioning any extension, then your protection is only territorial in nature. It is not extended to the out of this territory. Okay, and another thing is these are purely uh, creating a negative right. So you know what is negative right, what is a positive right. With this right, you are not going to do anything. You are not going to do anything other than stopping the other person to use your intellectual property. So then what is your claim, and with which intention you are taking your claim to the government? These are important, so that you are going to understand when you are dealing with the different topics. Okay, so with that negative right, you can exclude the other person not to use your right. Yes, of course, it is a statutory right. And that statutory right actually imposing the negative, creating the negative right. And while creating that negative right, it is imposing the positive duty against the other person. So right to rem, right to personam, you might be hear these words. In that way, I am telling that. And another point which we need to consider, it is not creating any permanent ownership and any permanent on the claim which you are taking to the government. It is only temporary in nature. You can't get lifetime protection except one thing, that is a copyright. So except that, but that is not anyway related to the startups. In some parts you can relate. Yeah, I mean, it is not true to tell that it is anyway not to come to that intellectual startups. So some point you can connect that, but purely it is not relating to the what you call a business model kind of intellectual property. Okay, so with this understanding, you can divide the entire intellectual properties into uh, majorly grounded kinds are three: copyright and trademark and patent, and the subsidiary kinds which we are taking from the main intellectual property segment. Those are geographical indication and trade secret, industrial design, integrated circuit layouts. So that we have that Circuit Design Act and the plant varieties. So in those trademarks and patent and the industrial design Act 2000, these are directly connected to the startups. And I told that central government scheme of 2016 is directly dealing with these three only: trademark and patent and design, not the copyright and not the plant varieties. Yes, yes, of course, they might be connected with the commercial aspects, but they are not dealing with that. In relation to those, government is not giving any support. And if you want to in that start a business model in relation to this, it is up to your risk, and you only need to sustain without any support from that. Okay, so with this, I'm directly going to the patent aspects. Okay, so these are the scenario which I am taking to you. So one point we understood what is the startup, and then we went to the what is intellectual property nature, and what are the categories, and which aspect are directly connected to the startup. Okay, so with that, if you understand the relevancy of this topic in current day trend, then I given a scenario. There 88% of the global patents which are coming from these four countries: so China, USA, Japan, and Korea. And if you want to see the Indian position, it is nowhere stand below that 50 countries. So 56 or 51, if you're going with that rank, in the year of 2021, India position is 56, I think. So then you can understand. One is India giving the support to the startups, our legal enactments, our proceedings in relating to the backup support are very stringent in nature. They are actually prevailing all the startups, but still we are actually lagging behind these numbers. Okay, and in recently after the intervention of these these programs, startup supported schemes, then little number is actually improved. Thereby you can identify this Indian position at 51 or 56 after these schemes support. But without which, where you can guess where we might stand. It might be 100 plus, it might be 150 plus. Okay, now the global rank by 2021. This global rank is purely relating to the patents, I'm telling. 46th. Before the year 72, that would mean 2020. Okay, due to intervention of these 2016 scheme, little extended, little improved. 5 times that patent grant is improved, and then the examination period is reduced. That is also affected the patent granting rate. So earlier it nearly taking 6 years. Now that reduction is with that reduction is actually saving the 2 years time. So with that, you can find that improvement that is caused to that 46th rank in at global level. Okay, so global level 46th. And what about the position of startups actually? If you observe that slide, so I mentioned that startup after the incorporation of that company, after the registration of that company, you can assume up to 10 years you are considering that as a startup company. But if you see in that pie chart, most of the companies they are filing their patent applications after 25 years. Minimum time they're taking for filing the patent application if they want to get that patent right. Minimum period is 25 years. Then how far it is conceivable to give the 10 years uh, to treat them as a startup company. And after 40 years only, you can observe the confidence at industry level. So that is the reason why 40%, majority of the companies are going by that 40 years. Okay, and more than 20 patents, you can't, the single patent only after 40 years also, they are going with the single patent, most of the companies. And very few companies are going with the more than the 20. So this is one of the minus point which there with our policy to compete with the rest of the world. Yes, of course, we are climbing ourselves as a in that Make in India and Digital India, but still the policies are running behind that slogan. In that way, also it is very required to extend it furthermore. That scheme which we stopped at 2023, it is very required to extend furthermore. So, and not only from the perspective of patents, if you see the trademark also, year-wise, 2018 to 2021 and 22, year-wise, gradual improvement is taking place in relation to the application of the trademarks. But when you seeing the percentage of all the trademark applications, then their percentage actually minuscule level. It is minimum level. It is not carrying the more than 0.5% also. So if you see 33 lakhs of trademark application filed in 2018-19, but in relation to startup, the applications are only 2,596. And the current year, that would be last financial year, if you see, the total applications are 34 lakhs. But at the same time, the applications which are filed from the startup side is 8,649. So there is a marginal difference, a marginal part taken, which is coming from the startups. So why it is happened? The direct reason is nothing but a lack of understanding, lack of the observation relating to the intellectual property. Soundfully, we started that scheme in the year of 2016, but still there is no awareness. One of the pivotal object in that scheme is awareness of the intellectual properties. And that awareness, to create that awareness, they are also called the educational institution and different organizations who are working on that intellectual properties and startup models. And they also consider the legal fraternity to be a part in this particular scheme as a facilitator, facilitator of that intellectual property rights. If some startup want to claim their intellectual property right, they can directly approach to that facilitator. He actually filing and he actually taking those claims to the government. If any objection come, he is actually defending. He is preparing all the paperwork till the getting of that claim. Entire support is coming from this facilitator. That facility is created by these patent authorities and trademark authorities and design controller general of patent, nothing but. Okay, but that awareness is still not that much convincible. Yes, of course, you people also need to know why, because if you have a little bit of awareness related to the IPR, you might be go out to that world and you can tell to your adjacent person, this is the importance of IPR, this is the importance of your brand, this is the importance of your invention. If you taking this claim to the government, if government is recognizing your right, then you can see your dynamics, economic dynamics, and you can see your value in the financial system. So in that way, you can convey these things. That might be reason to create this lecture. So then come to the patent. So I'm not taking to you taken to that sections that is not so required if you understand the concept. Okay, so sections are only namesake things from my understanding. It's nothing but the to quick identification only, we are actually going with the sections. But you need to understand the concept first, so that you can, by going with these 3 lines, you can understand what is exactly patent, what actually we need to consider while going to that, while going to get to that patent protection. Okay, this is actually in red color highlighted words, very important to understand. So patent may be divided into 2 kinds, a product and a process patent. Whatever it may be, whether it is relating to the goods and whether it is relating to the services, so these are not important to consider. But it can be taken for product, it can be taken for process. And I told that it is creating the negative right. In that way, it is excluding the others to use that particular right, which is created on behalf of you. So that right is absolute right. And when you treat that as a patent, it is creating a commercial right. Okay. So if somebody actually intervening on that matter, then you can take a legal action. Then which are that actually entrusting that patent right to you? It is nothing but the government. And at the end of the this session, I will tell a small thing relating to the how far this government is relevant to grant that patent right. You ask me. Okay. So then you can identify the authority which is actually giving that patent, granting that patent. Okay, it is granting that patent on behalf of the inventor, and with that, these authority, this patent holder actually excluding the others to use and making use and sell and other related things like license and the extended part of this patent grant. Okay, and while getting that invention, you need to identify the for the patent, you need to identify the invention. So when you're treating one thing as an invention, so in general sense, which what way we are understanding that novelty and non-obviousness and inventive step. So in that way only I mentioned novelty is nothing but the newness. So which is not already existed in the world. And this person, the person who is actually invented, he is taking that out and he is disclosing to the public at the first instant. In that circumstance, you can treat that as a newness. Okay, and if you go into that technical way, you need to understand the prior art. Prior art means there is no existed knowledge, advanced knowledge in relation to one particular aspect. And you are the only person to take that out and you are wanted to disclose with the protection of the authority, government authority. So that is actually a catching phrase of this image. And non-obviousness. So if something is happened, if with that happening, if you find the certainty, then it is not actually falling under the attributes of patent. So non-obvious is one of the element which you need to disclose while getting that patent. Okay, what are non-obvious, what are obvious, which you can understand a little later. Before going to that, 3 things you need to identify. One thing, to treat one thing, one particular invention as a non-obviousness, that is actually the invention if it is not falling under the concept of stupidity and the concept of the regularity and the concept of the state of art. So then you can find these non-obviousness. So in what way I'm telling that you are going to understand for the sake of in that this slide up to this is enough. Industrial application in another attribute which you need to entrust to that invention. Industrial application means so you need to use that particular product for the manufacturing purpose or that need to be happened during that manufacturing. And another thing is if it is process related patent and that is also possible with this industrial application. So then these are the attributes which I mentioned here. You can find in that section 2M and that and 2P, 2J, 2JA. On all these sections are dealing with these attributes which I mentioned. So initially I didn't mention these, those are not so required if you understand the concept. Then when you have some kind of dilemma and in that difficulty to understand these newness and the non-obvious and the industrial application, then you can catch this section 3 of the non-patentable thing. So Indian Patent Act section 3 is actually carrying few things which are actually not subject to get the patent. If you want to understand those things, then you can understand what exactly a matter to get the patent. Okay, frivolous invention, useless things. That's why I mentioned that. Stupidity is not a subject. No, so if someone is invented his stupidity, you can't treat that as an invention. And contrary inventions, which are against the natural law. Okay, in that terms also they are not subject to patent. Okay, and harmful inventions, yes, with that, if it is okay. Ma'am?
Yes, Kiran, can proceed.
Okay. So then come to this mere discoveries. You just invented the, you just identify the thing which is there in nature as a phenomenon. So that is the reason why we are not considering that Isaac Newton's gravity as an invention. So that is a mere discovery, not an invention. So to consider one as an invention, you need to follow the inventive steps. One is there should be advanced skills, and that advanced skill you may not be find in the much earlier as a prior art. Then after industrial application need to be happen. If these three are missed, then it is nothing but the mere discovery only. And admixture, you just added the things which are already existed. Like I mentioned there on the slide that a teacup. So we're adding the tea powder and sugar and milk. Then after we were taking the tea, then it is not an invention. It is just admixture of the things. And mere arrangement or rearrangement or duplication. Duplication anyway you can understand. And what way you can consider that arrangement and rearrangement. So there I mentioned one fine pencil and which is interested with that eraser. It just the two different things. With that combination, if you want to get the patent, it is not possible. Both are two different. You are just only rearranging them as a one segment. In that way, also it is not a patentable subject. And another point is agriculture and horticulture related things. You want to aquaculture. So these methods on them, everybody carrying that ownership. If you want to get a monopoly over that, it is not permissible. That is the reason why they are not a patentable subject. And the medical and surgical, whatever the medicinal purpose we are using, that knowledge is not actually a patentable one. So whatever the method which we are using as a curative one, a diagnostic method to test one patient and to conduct a surgery. So all these methods are actually a non-patentable one. And I mentioned in the beginning plant varieties and animal breeds and all these things, sir. You might be taken in altered way, but still these are not a patentable one. But because to protect them, we have different set of establishment under law, but not the under the patent acts. And then mathematical and business models, computer program, all these are coming under the different law, that is copyright law. Those are not subject to here. Okay, and in the same way you can understand the algorithms and literary works. So that literary, dramatic, musical, artistic, all these are subject matter of the copyright, not the patent. Even in games also. Why they are not patentable? Though you might presume it is required to protect those kind of aspects, but still they are not patentable. Why? Because we have trademark law, we have Design Act, Circuit Design Act, and we have Plant Varieties Act, and we have Copyright Act. That's why these are got exemption here in this. And presentation information which I am presenting here, it is also carrying some kind of rights, but it is subject to copyright, not the patent, like integrated circuit. And in traditional knowledge also now these days that that concept of traditional knowledge is actually rampant in nature, like geographical indications. For that also we have separate law. That is the reason why they are actually ignored to consider them as a patentable thing. Okay, so I hope now you understand what are the patentable subjects and what are not patentable subject. Okay, then how you are getting that you are a small entity, now you started a business, now you want to get the patent protection. So for that, if someone approached and or if you yourself wanted to get that protection from the agency, then how anybody if they ask you, then what we actually doing, we taking our application, we are taking our claim to that agencies, and with that we are actually getting that protection. So initiation of every protection is nothing but the application. So with which you are actually taking your claim to that government. Okay. So for that, who can able to take that application? So inventor, true and original inventor, the first party who can always take that. Under his assignment, assignee also claim that first inventor position. And other than this, any legal head can take this application to the government. So original inventor legal representative and the assignees legal representatives. So there is assignment between two parties, inventor and the other party who is actually considering as a assignee. So on behalf of these two parties, you can take take that application to patent office. So what actually required with that application? One is covering letter who is taking that application, and I'm actually disclosing the procedural aspects of functional aspects of that patent getting procedure. Okay, so you need to first disclose you need to make a cover letter in relation to your claim, in relation to your invention. Then after, what exactly you are seeking from the government, that is grant of patent, is nothing but the asking the right from the patent authorities. And with that, you need to provide the complete and provisional specification. Complete and provisional specification means, yes, I mentioned that complete means what is the title of your invention. For example, yes, of course, it's a kind of instrument which is operating a computer program. You invented that. So we need to put a title for that invention. And what is the abstract of that complete instrument that you need to give in a brief? That is the preamble of that invention. Then in relating to that invention, is there any prior invention or not? So you need to identify the prior art. That is actually doing our own selves. And sometimes you can also request the others to do that on behalf of you. But if not, it is your concern. You need to do that as a matter of important. And it's a very required one also. So prior art test you need to conduct. And then after, if you identify any prior art, with that, you no need to stop. You can disclose your invention to the patent authority, but with the contention, what is the drawback which is there in that prior art? In what way you are actually improved your instrument to overcome that drawback? That you need to disclose to that government. Okay. Then another important thing which you need to mention, the solution which you are providing. First, you identify the prior art, and then after you wanted to overcome the drawback which is there in that prior art. So that is actually solution. So invention is there, drawback is there, and you now come with your suggestion. That is your solution. Okay, an entire invention you need to give it in a brief. That is the summary, and then you are giving the statement of your invention, with what purpose you invented, what exactly the utilization of that invention, and in what way you are going to use that. So this entire thing you need to specify. Then after detailedly you are giving the information to the authorities, that is this detailed description of the invention. And with reference to diagrams also you need to disclose that, and you need to in the diagram also you need to make a name to each and every part which you are using in that invention. And if it is required, then you need to give the examples, and each and every part you need to give your claim in relation to this particular segment. What is your claim, and what is the in that details of that prior art, how you are overcome all these details. Each and everything you keenly need to disclose to that agencies. In that time only it is treating as a complete specification. The details which you are disclosing to that government authorities, patent register, in related to your invention, the complete details are come under the purview of complete specification. If you are not ready with that complete specification, that law is not going to stop you to file the patent application. You can still avail that, but with the mentioning of the provisional specification. Temporary specification. What is your invention? What you are going to do with that invention? So that you need to at least mention, without which it is not going to taken into consideration. Either if you are coming with the complete specification, no doubt, or else you need to provide that provisional specification. Then after you need to make an statement which is actually carrying the undertaking of your responsibilities, and then after how you are mean that disclosing our invention. And yes, of course, public policy and morality also considerable issues in this statement of undertaking. And on behalf of you, if somebody going to file that application, then that power of attorney you need to enclose with that patent application. And declaration of inventive step, what is the process you followed, what are the in that inventive steps you mentioned there, all these you need to disclose in a proper way. Okay, and then with that application, you also need to file the form 18, that is nothing but the preliminary examination. So after filing of the patent application, after certain period of time, these patent registry directly going to initiate that examination part. So to that initiation, that automatic initiation need to be taken place with the intervention of Form 8. That is the reason why with the application we are filing that Form 18. If you forget to file that Form 18 in later stage, somebody need to do that examination. So that is the responsibility of the government register. That is the reason why they are taking a prior permission from you to conduct the examination. Without your intervention, the government is not going to do with that invention. That is the reason why they are taking that. Yes, of course, requisite fee is also important one. Okay, then I will tell this is the process, a general process, what you need to go with that complete specification. And what required documents you need to provide to that agency. But step by step, how these are taking place and which aspects are more important for the startup and what way this government is changed this patent application system to improve these numbers, what we have seen in the beginning. So to get that numbers, to get that best position in the world order, so what actually changed in patent process? If you understand this diagram, then you can understand in what way that change is taken place in favor of the startups. Okay, so I mentioned that application may be taken place in two kinds. One is application with the provisional specification, and second one is application with the complete specification. If you file the provisional specification application, then the law is giving you the time of 12 months. Within 12 months, you need to file a complete specification. Failure of which, then the application treated as a abandoned application. Why it is treating as a rejected application? Why it is so treated as a abandoned application? That would mean the intention right behind to file that provisional of specification is to fixing the priority date. The date which you are filing that application, fresh application, is actually fixing the priority date. From there onwards, your protection is actually begins. If you file the proper and formal application in the agency, then that agency is fixing the date. That date is nothing but the priority date. That priority date is actually starting point of your protection. So from there onwards, you can disclose your work to anywhere. You can announce that work in the public. You can publish that work also. So it's not going to restrict you. But before filing that provisional application or complete specific application, if you mentioning that work in a public, and if you are publishing that work, then your priority is actually existed. You yourself is killing your own interest by disclosing that invention to the public. So that is the reason why. So till that fixing of priority date, you are not allowed. So you are very hurry in moment, but still that work is in progress. In that time, you can file the provisional application. Then you can utilize that cooling off period of 12 months, and with that you come with the complete specification. I mentioned that what is actually a complete specification. Okay. What are the things which you need to disclose with that complete specification? In the earlier slide, you have seen that. So then after 12 months, you need to file the complete specification. Then if you are a startup, if you are an educational institution, or if you are a women entrepreneur, so these matters are not our cup of spoon now, then you can take direct a startup. So when you are a startup in that so if that application coming from the startup incorporation, then you can request the agency to conduct a early publication. So for that, you need to pay extra amount. then that is after taking that requisition, whatever the point of time you can request that agency, after receiving of the application, within a 1 month, actually that patent office is publishing that application. So when that publication is coming out, then it is subject to the public objections. If some interesting party is out there and he might be see your application and he is coming with your objection. If not, early publication request, then after 18 months, automatically this government agency is publishing that patent application to the public. So that is the reason why we actually mentioning that Form 18 in the beginning of filing of application. That is the importance of Form 18. If you're not mentioning anything, then automatically regular publication is happening after 18 months. Otherwise, early publication also you can carry. Okay, so then after publication, it is actually taking the pre-grant oppositions from the public, whoever claiming their interest or the interest which you disclose to the patent office. So on that, they're actually making some objections. Then sometimes that objections also coming from the patent officers. Filing procedure, if anything is wrong, and when they are going with that, if there is any technical errors, that they can take the clarification from the inventor or the applicant who filed that application. Okay, so those are actually treating as a pre-grant opposition. Then after, it is subject to request for examination. There also there are two kinds of examination. One is regular examination, it is taking place 48 months. So to complete that regular examination, actually it is taking 48 months. Or else, if you are a startup company, you can use that by filing 18A form, and then with that intervention of the form 18A, the government is actually conducting the quick examination to grant that. And sometimes to look after that startup company well-being, it is actually granting that patent, then after it is actually conducting the examination. So anyway, it is subject to objections only, but the nature of granting a patent is little altered in favor of the startup company. Okay, examination is actually conducting with the two objectives. One is whatever the claim which you are mentioned, are those claims are patentable, or what are the requirements you still furnish to that authority. In these two ways, actually that examination is taking place. Okay, so after examination, it is actually giving the first examination report, a PR, to that inventor to take his objections. If he required to add something more in relation to that examination report, so then he can add later stage, and also he can request to conduct the re-examination. So in that way, it is providing that first examination report to that patenting, the applicant, sorry, patent applicant. Okay, and so whatever the objection you want to take and whatever the necessary aspect you want to disclose to that patent agency, that you need to take to that authority within a 12 months. If you are not taking to that 12 months, then again your application considered as a abandoned application. Abandoned application, again I mentioned that it is not the rejection, it is abandoned. That would mean you also can file a fresh application. Only thing is your prior date is actually missing. So that is the reason why it is not abandoned for priority date, but it is still subject to file a fresh application. If you are actually complied with all the objections and obligation which are fixed by that patent authority within a 12 months, then they are actually granting that patent. Patent is nothing but the certificate which is entrusting for some rights which I mentioned. Those are actually exclusive rights. So that is actually patent filing procedure at domestic level, that too more particularly in India. Okay, then all these process, which is taking place nearly 3 to 6 months, but For the rampening of these startups and to well-being of that startups, they're actually redeem that decrease that cooling off periods and outer limits of the dates to conduct the examination for publication. All these are actually reduced to see the benefit of these startup companies. So then, and another important thing which here we need to understand, I mentioned in the beginning also while starting this discussion. State patents are territorial in nature. All the IPRs are territorial in nature. They are not creating any international right. In the same way, patents are also territorial in nature. And this is a statutory right. But how far you can extend your right? You are a small startup in a given country. Say, for example, India, in India, you are incorporated as a small startup and you want to get protection in outside. So beyond the boundaries of India, you want to get the protection. Is it not possible or not? So even you can, being a startup also, you can claim the international, protection, but that only possible when you are filing the PCT application. So international application, in which countries you need to take the protection, that you need to mention. So though you file at a national level, and then after you comes to know your interest is, it is good to protect in different countries. And within 12 months, you can file that application in international authorities like WIPO. It is actually has a provision of PCT application. Okay, so you can take your claim to that agency, and it is actually conducting the examination to grant that protection in different countries. So in which countries you want to get the protection, that you need to mention in that application within a 12 months after filing up the national application. That is the reason why. So it is little tricky to understand the PCT application. But once you observe that slide, then you can, it is easy, not that much clumsy in nature. Okay. So when you are going to file PCT application, there you can find 3 stages. One is PCT application filing in national level. Then second one is PCT application at international phase. And third one is PCT application again to that national phase. PCT application in first filing phase means it is existing at the national level. For example, I filed my application here in India in Chennai Patent Office. Okay, then I came to know I have the provision to apply the patent protection in different countries. Then I am asking the Chennai Patent Office to get that protection in different countries while mentioning those countries. And I'm also requesting the Patent Office to convert that application as a PCT application. Then to convert that application as a PCT application, that the law is given the 12 months period. And within 12 months, you need to mention in which countries you need to get that protection. Then after this PCT, patent filing agency at international level, it is there with the WIPO, it is conducting the international search. So the patent search in general, we are considering as a patent search. It is conducting the search and it is giving the report to that in patent applicant. Okay, if any amendment is need to be taken place, it is suggesting that, and then after it is giving this examination report. So till 18 months, it is actually giving from the filing of first application at national level till the 18 months. Even that WIPO is also giving the support to that each patent applicant. So in what way you need to improve your application? What is the prior art? So, and what way you need to disclose your invention to get that protection? So all these are actually disclosing with their examination report. So if you are observing that report, and what way you need to give your contention that you can understand and you can modify that application. Then after you can approach to that international agencies, and also you can give the suggestion to that international agencies to conduct a re-examination. So after filing of the first application, till 22 months, it is actually conducting the examination process and it is giving the preliminary examination report. Then on that report, if you have any objections or if you want to make any amendment, you can ask the internal agencies. And after considering your objections and your contention, within 3 months, it is actually forwarding that report to that countries. It is actually treating as a communication to the countries where we actually wanted to get that protection. For example, India, you filed as a national application. Now within 12 months, you ask the WIPO to treat your application as a PCD application, international application, while mentioning the different countries' names. For example, Pakistan, Sri Lanka, Nepal, like that you mentioned few countries' name. In all these countries, you want to get protection. And it is actually conducting the prior art international organization. Then after it is giving the report, and after thorough examination, it is sending that report to the each and every country where you mentioned to get the protection. Pakistan, it is sending the report. Bangladesh, it is sending the report. Nepal, it is sending the report. Sri Lanka, it is sending the report. It is the final stage of PCT application process. So once it is reaching to that national stage, then the national stage is a regular process which we actually dealt just now, this process. So always remember, friends, once you file that PCT application, it is not abandoning the states. It is not abandoning the countries to do entire process. It is only conducting the examination. It is only giving the reports to each and every country which you mentioned in that PCT application. So this report is actually backing support to that applicant, but each and every country process is same. Each and every country is same. But what is the advantage of filing a PCT application means you are actually saving the time. And second best important thing is you are fixing your priority date in across the world. In each and every country, you are fixing that. That is the advantage of filing a PCT application. Otherwise, if you are filing in India and you are waiting for till getting up that patent grant, then after you are going to that China to file that patent application. How much time it is taking place? 5 to 6 months here, 6 years here to get that patent. Then after you are going to that other country. So they are also the same kind of time taking. Then what is the time period to get that the term of the patent protection is how much it is? You might know that. So 20 years. So in all these 20 years, you are actually running for that getting the patent in different countries. So that is the reason why time is very short. With this all process, at the end of the day, the term of protection is only 20 years. To avoid this delay only, this PCT application is actually very convenient for the startup companies. Okay, so then I mentioned there in that slide, 20 years is the maximum period one will get, and that 20 years period is starting from the filing of the application. Remember, starting from the filing of application where that priority date is actually fixed. From that date onwards, 20 years is the maximum period one will get that patent protection. That includes this 3 years and 5 years period which is taken place for getting a patent protection. At maximum, one can enjoy that patent right 15 years. That's it. If you get early that patent protection, then 50 years you can enjoy. Then after, what's going to happen? It is going to a public domain. Then you can treat that as a prior art and you can treat that as a state of art. You can nothing to do with that. Everybody carrying the right over that knowledge. Okay, till this 20 years, you can manufacture that product, you can use that process, you can acquire all the financial interest out of that, and you can also obtain the royalties by giving the license to the others. So you solely have that right, and you can block the competitors. This patent is actually an extra layer to get the protection. Okay, So this is all about patent. Then I moving forward, the next important aspect in relating to the startups is a trademark. Okay, each and every startup may not carry that patented invention. It is not so required because it is a lengthy process, and with the statistical scenario also you can understand. After 40 years of the time only, you are actually coming with one good invention. That would mean by that time you are actually missing the attribute to treat you as a startup. That is 10 years. So then there is no relevancy to treat a startup in relation to the patent. So in that way, it is also very optimal one to extend that ES to treat one agency or one organization, one corporation as a startup. Then if you come to this trademark is actually giving a good boom to that startup companies. It is actually giving a good support to that startup companies. It is nothing but branding of that company. With that brand, you can have a market strategy. You can have a financial strategy. It is improving your condition. It is labeling you in what way that company is actually manufacturing the goods. What is the quality of that good? With that, everybody knowing the value of your company. So it is that trademark is actually improving your value. And you are also identifying your target audience. So what is the importance of identifying the target audience? So if you once you select your audience and you are manufacturing that goods by keeping the view of those particular group of people only, then your particular sector is not going to miss whenever the change is taking place in relation to your good. Okay, so you might be seeing this kind of scenario. Many of the years you were habituated to use one product. Even after changing of that product also, it's not convenient to you. The change is not actually convenient to you. You still using that product because of your very compliance with that. That is actually importance of this trademark. It is actually improving your brand image. You might be a small one, but the impact which you are actually having in the public is very strong in nature. Okay, so with all these marketing condition is also improving, and it is easy to take your step, your inventions to the public, your manufacturing to the public. It is very easy. So you can easily notify to the public with your brand value, with your labeling, with your logos and all these things. And I told that it is assuring the quality. If it is the product of this company, what quality is which you can assume that is always understandable. And other than this, not only commercial point of view, and but at one point of time, you are also emotionally connecting with that public. Okay, we are all know connecting the people that Airtel tagline and also BSNL. So all these are one point of time all they are doing the commercial business only, but we are all actually missing by losing that product. While buying those product only, we are seeing the value. Then after we are actually treating very lovable, and we are actually emotionally keeping them. So that is actually happening with the these trademarks. Okay, then what is exactly a trademark? So with the four lines you can understand, which are there on the bold font. Those are very important. So mark is actually an inclusive one. You can include whatever the thing. So if you are if you are sensing those with your five senses, then that is the mark. There is no further iteration to understand the mark. So if you understand the what you call fact, what is the actually a fact? The fact which you are perceiving with your five senses, that is fact according to the evidence law. Then the same kind of iteration you can iterate here also. The mark which you are perceiving with your senses, that is actually a trademark. That's why many number of marks came into existence. Sound marks, fancy marks, collective marks, graphical marks, tone marks, fragrance marks, smell marks. So there is restrictive meaning in related to marks. It is all inclusive in nature, and that mark need to be capable to represent you graphically, and it is also need to be capable to distinguish your good, what you are manufacturing, and your services, what you are offering with the other person who are offering the same service. Same service. Sometimes BSNL and Vodafone and Airtel offering the same kind of service, telecommunication service. But you can understand the quality of that service. You can understand the financial what you call which one is the cheapest one, which one is the costly one. So with the you also understanding with that. So with that you can keenly bifurcate the two goods, and you can keenly bifurcate the two services. Okay, that is actually the distinguishability is the functional aspect of the trademark. Whenever you are wanted to register one mark as a trademark, then the functional aspect is how far your mark is differentiating the others. That is your quality. That is your pure sense. Okay, and the further extended things are shape of the marks and packaging, combination of color. Few things are not not necessary to understand. For example, shape of the goods, actually a subject matter in the Design Act, but little alteration is there that I will discuss while discussing with the Design Act. But for sake of understanding, you can also include the shape of goods, packaging, and combination of colors as a trademark. Okay, I'm giving a kind of example to understand the different marks. So whatever the definition you are reading in the trademark, all those are picturized on that slide. So device mark is example of the mobile phone. Nokia connecting people is the tagline. It is also a trademark. So combination of figure and word is a trademark. That next step. Number 555, all might know what is a 555. Signature, lettermark, McDonald's, Microsoft. Package is also carrying that. It is also a subject matter of design, but while understanding the design, we are actually seeing a different phase of the design. Code mark, name, Metro Gold Mail, combination of color. The same kind of combination of color also you can see in design, but here the understanding is different. You are representing yourself, but design is different. And I mentioned Windows Professional XP, there some kind of animation is running. That is also a trademark. And label, when you are buying the jeans, there you can identify a kind of leather tag. There some of the text you can see. That is also a label. That is also carrying a trademark, right? Okay, shape mark. Coca-Cola is befitted example to understand the design and patent and trademark. You mentioned the intellectual property mark, then you can take the Coca-Cola as an example for. Right. So all these mentionings are you can find in the definition of the trademark under the Act. Okay, understand the section is not important. That what that section is telling is important. That's why I'm actually picturized all these things. So I mentioned while defining that trademark, mark is not the restrictive one. It is actually inclusive one. Inclusive in the sense you can find the goods mark like Pepsi, Adidas, Maggie, Apple. And at the same time, you can also find out the certificate of mark. To get the certificate of marks, you need to have an authority. Like ISI symbol who are giving actually the government authority. So Food and Corporation Agency also giving one authority, wool mark, AG mark, the PIVO mark. To grant all these marks, actually you need to carry an authority, legal authority. So through those person only, the certification marks are meant. Otherwise, without which you can't get that certification mark. And the collective mark, the group of people actually carrying the interest over those marks. In that case, you are treating that as a collective mark like CA. CA is registered one. So then the distinguishability of that CA mark also we can see that strike is actually reverse in nature. Okay, chartered accounts, company secretaries. But relating to the law, that mark which we are using on vehicle, we are not registered. Across the globe, that mark is not registered. So, but remaining that company secretary, CPA, all these marks are registered as a collective mark. And suggestive mark, service marks, Walmart service, Amazon. If you see that A to Z service is its distinctiveness and distinguishability. It is offering the A to Z goods. That is its uniqueness in that mark. Okay. And the Taj Mahal Hotel, which is there in Rajasthan, also offering a kind of services. And relating to those services, is actually acquired the trademark protection. Okay. FedEx, we know that the courier service. The FedEx term is not important to understand. In what way they developed that word? If you see in between E and X, you can find the arrow, which is actually going to that right direction. So that is making that distinguishability. Airtel as a telecommunication service is example for the service mark. Then well-known and popular marks. Well-known and popular, with which you can understand what kind of service it is actually offering. Okay, what the goodwill and what is the reputation of that mark. So that is also classifying one class of marks again. So Bisleri, Bata, Mahindra, Tata, all these are Volvo. How many of you know Volvo is involved in the manufacturing kind of business? It is actually constructing big buildings and bridges. It is also involving in the laying of the roads, transport. But till now we know that is only actually manufacturing the cars and big trucks. No, it is also involved in the constructive kind of works. Okay, then you can understand if Volvo constructed, how strong it is. That is actually a brand value. That is actually a perception which is created by that logo. Okay, then to register one mark, what you need to disclose to that. So I want to register my name as a trademark. Is it possible? If I registered Kiran as a trademark, then it may not be possible. So how many of you know Annapurna Hotel, which you can find in each and every town in the AP? Every place, even in small village also you can find that Annapurna Hotel. If you want to register that Annapurna Hotel name as your trademark, is it possible? No. Why? Because it is a state of art. Everybody carrying the ownership over that mark. Then in what way you are taking that protection? To get that protection, what kind of trademark we need to use? That is the importance to understand. Okay, that's why Amazon is actually mentioned that A to Z. To connect these A to Z, they mentioned that arrow. FedEx, they use that arrow mark. So your mark should be a distinctive one, descriptive one. Instead of using Kiran, if I made my trademark as a YBKK, it might be convincible. Instead of Annapurna Hotel, if you're using AH as a hotel name, then it might be convincible. In that way, you need to take your name to get that registration. But while taking that to that the registration, you need to consider few things to avoid. What need to be avoid? Public juries and generic words. Annapurna Hotel is a generic word. Public carrying the ownership over that. So I hope you understand why everywhere you can find this Satyanarayana Hotel, Annapurna Hotel. In a native way, to understand in a native way only, I'm taking these names. So these are actually generic words. Okay, deceive the public and causing the confusion. You are manufacturing a good and conditioned mineral water, good and conditioned mineral water. But that label which is showing on that water bottle is actually named as a danger. It is actually causing confusion. Water is very good, we are all consuming, but it is labeled as danger. In what way you are going to use? Even if you are disclosing in the public also, if you are actually, announcing in the public, it is actually meant for the drinking purpose, then no one come forward to you and they are going to buy. Why? Because it is causing confusion in the mind of public. So that is also you need to avoid. You are doing good job, but you are actually making some kind of in that confusion. And if you had the religious interest of the public, it is also not subject to get the registration. So there, I'm sorry, I actually in that reverse and that symbol, cross and some religious symbol. So it is nothing but the affecting the religious morality of the public. These are not acceptable to register that as a trademark. Okay, and I also use that blurred image. Those are the scandalous ones. So most of the IPR policies are actually evolved on the basis of public policy and morality. It might be carry a lot of, that financial interest, but still, the one country policy, and more particularly in India, the policy is actually evolved on the public policy and morality, and that is the reason why these are all many things are not may not be available in the USA and China. There you can use any mark as a trademark. Obscenity is not an important for them, but for us, we need to avoid that kind of obscenities. Okay, and if the shape is naturally came into existence, then apple is apple. How it looks like that everybody know. If you want to get that as a trademark, then it is not possible. Okay, and in the same way, you can understand the technical result. H2O. What is that H2O? It's water. And if you are manufacturing manufacture of that water and you will label the yourself as a H2O, then others are not selling the H2O, you are only selling. So the technical result, if you want to use while doing that business, they won't accept. Okay, and if the mark which is giving a substantial value to your good, then is also it is not convincible to get the trademark registration. 100% pure water. It is added value to good. Pure ghee. All people are using you. If you go to the supermarket, these kind of iteration you might be seen in a number of that goods. But still, you can use. But if you want to register legally, then they are not permissible. Without registration, you can use unconditionally. But when the moment you are taking for registration, there that restrictions are comes into existence. Okay, because on this, the interest is everywhere, interest is sustained to the public. So the landmark cases which I mentioned, there Starbucks versus Starbucks and Paytm versus PayPal. The names and styles are very similar. All you might know what are those companies and what business they are doing. It's a small company. Starbucks is a small incorporation like startup only. But the moment when the Starbucks is filed the case, it paid the crores of the compensation because of deceptive similarity. So these things also you need to look after when you are taking your mark for the registration as a trademark. Okay. So once you get that registration, the protection which you are availing for your mark is 10 years. Okay, it is also except patent, every IPR protection is meant for lifetime. Here also trademark, you can enjoy the trademark rate for lifetimes. But only thing is each and every year you need to renewal for after first registration 2 years you can enjoy, but after 2 years every year you need to renewal till the life. Okay, otherwise they are seeing for 6 months, then after they are actually keeping that aside. So you need to renew that mark, revoke that mark, reuse. So you need to pay certain amount of fee to renew that mark, reuse that. Okay. Then if you are not registered that mark, then what going to happen? So this is non-registration of one intellectual property right. Is actually making a good difference when you comparing with the patent and trademark and design and copyright. So I mentioned in the beginning of the discussion also, if you are not registered also, no problem, you will get that protection. So we have the two kinds of legal system. One is civil law and one is common law. All we are discussing only a civil law kind of establishment. But your remedy is already established once you identify your right, that is there with the common law. So whenever the moment it comes, that would mean if dispute comes, if you're taking your claim to the court by disclosing your right, law is always there that ready to protect your right. That's why we have that famous phrase called UBJ's IB rule. Disclose your right properly, then this law is also that much proper to protect your interest. Disclose your right confidently, this law is also confident enough to protect your right. So that is the reason I'm telling that. But it is not possible with the patent. Patent is definitely you need to register and definitely you need to get the protection from the government agencies. But in the rest of the intellectual properties, the trademark, copyright, designs, all without registration also you can claim. That remedy is nothing but the passing. Okay. So then we are moving to that Design Act. So I mentioned that these are later stage actually subsidiaries of the main intellectual property segment. Okay, so I will show the appearance of few things. Then all these are, for example, to better understanding of the design, I will give a small example. Then you can understand what is the fine difference between this trademark and design. If you assume KFC, if you start thinking about that KFC, what comes into your mind? Is that leg piece or chicken pakoda or the smell or the way of their appearance? Definitely smell and the taste only. So 90% of the people definitely agree with me. So once you start thinking about the KFC chicken, then this taste and smell only comes into your mind. But when you start thinking about these figures, their shapes only comes into your mind because rest of the things you don't know. That's why trademark you need to understand with the definition of the fact which is there in the evidence. But design only eye appeal. Eye appeal is enough to treat that as a protectable design. So you don't know this product smell. To some extent, Coca-Cola is exemption for everything. I told that it is subject matter of trademark, patent, design, whatever you name it. Coca-Cola existence is taking place. Okay, all these are designs. They are only eye appeal. Okay, and another possible differentiation is when you understand the design. Design is always a part in that article. You can't separate that. You can't separate that. For example, if I show this water bottle, you can get this design for this entire bottle, but you can't get the protection for this label. If you want to get protection, you separately take that protection, but cumulatively you won't get this. Law is not permitting you. But in related to the patent and trademark, differently you can take, separately you can take. Each part will get a different protection under patent. But when you get that design, you can't get that what you call the same kind of protection in each and every part. Separately you can take. Okay, that is the fine define. One is it is only a visual appearance protection, and second thing is it is not it is not a separate kind of protection for the each and sorry, it is not including the each and every part protection. You need to get the separate protection for each and every part. Okay, so label, you want to get that protection, and the colors which you are using on that label, you need to take the protection, but or else they are need to appear in a cumulative way in the single form. You need to take that is the fine line to understand the trademark and this design. So, what features you can identify to understand that as a subject matter of design? Shape, configurations, different patterns, ornaments, lines, all you might seen on that the trademark example slide. But here also we are seeing. But remember, friends, whenever the design and trademark comes, the fine line is that illustration which I given KFC and the product which you are seeing. I appeal, I appeal, I appeal. By seeing, you are understanding one article quality, then that is subject of design. By seeing, you are understanding the overall quality in overall aspects, then that is the subject matter of trademark. Okay. And these all features you may entrust to the 2-dimensional, 3-dimensional, and sometimes you may use this in both ways. Okay. Your understanding might be like this: the shape which you are applied to the 2-dimensional article, which is prepared manually, is subject matter to design protection. In Bare Act, or if you go with that legal stipulation, it is giving a paraphrase definition. But each and every segment, if you differentiate, then how we need to read? It's a shape. It is applying to the 2-dimensional article and which is prepared by the manual. Then it is using an industrial process. It is subject matter of the design. Okay. But when you comparing with the other kind of what you call legal intellectual properties, the design protection is not that much difficult to understand. There is no timeline. First of all, there is no timeline. Statutory timeline. I'm telling that there is no timeline. Just you need to give your application to that agency. That agency is actually examining that. So I mentioned that registration process, that agency is examining that. If there is any objections, then it is raising the objection to that applicant, and applicant is coming with his contention. It is actually giving the reasons. Then after the subject to publication, if somebody actually contrary to that publication, then he is coming with his obligation objections. Then this applicant is giving his contention. Once the registrar is actually satisfied with these objection compliance, then he is granting that design protection. That's it. There is no statutory time limit, remember. And the cost of that getting design protection is also very minimal, 2000. And what my suggestion from my side is, if you are really carrying interest in relating to intellectual properties, find out small startups in your area and try to get a protection of trademark and design to those persons, because the process is very simple, very understandable, and the money also very convincible. If you want to file a trademark protection, just 2,500 rupees for normal application. If you want to file a conventional application also, 2,500 is enough. Conventional application means the treaty parties, bilateral agreement. India, if you have bilateral agreement with other country, if you file here also, you can get the protection in another country. If someone filed in another country also, that person will get the protection here in our country. In that way, conventional application is filing. For that conventional application also, 2,500 is the minimum. Okay. And if you want to register the multi designs and the multi trademarks, then each trademark you need to file 2,500. And if you want to register your mark for different class of people, each class only cost is 2,500. Class means, friends, if you filing a trademark, WIPO actually categorizing the goods and services into a 45 classes categories. In those, 1 to 34 are meant for good classification. These are generally treating as a nice classification, NICE, nice classification. So 1 to 34 are treating as a goods classification, under which category your good is actually falling. For example, it is a drinking water bottle, it is falling under the beverages. If it is a snacks, it is falling under the food items. If it is a tourism service, it is falling under the travel and tourism services. Like that, it is classifying. You need to mention that classification. That is actually treating as a nice classification. 1915 and around YPI is actually classified those. Every 5 years is actually to republishing that classification. Those 1 to 34 are goods and 35 to 45 are service related classification. In the same way, in related to design also, we have Locarno classification. There you can find 35 classes of categories in which service or which your design in which category it is false that you need to identify. You need to disclose to that registering agency. Why it is so important? This classification means you might be providing the same kind of service. You might be manufacturing the same kind of design. You might be manufacturing the same kind of good, but your mark is different. That is one thing. And you are using the same mark, but the classification is different. Okay, these are the defensive arguments to take to that court in order to sustain your claim over that mark and goods. So that is the reason why mentioning of classification is very important. So that's why I mentioned that NICE is meant for trademark, Locarno is meant for the design. Okay. Then once that objections are complete, then design protection is granted. So with that design, what you actually getting? If you have that patent right, get the register certificate and copyright protection. And also that registration also give the protection against the piracy. If somebody in that counter engineering that design which you are using, which you are registered, then you can ask the protection from the government. It is more what you call TM1, TM2, TM5, TM6. What are those forms? What those forms are actually conveying to that registration. So all these are very necessary to understand. When you are going to know that, when you are going out to help the startup companies, and while doing that, you are learning all these things. Okay. So in that